warahmatullahi wabarakatuh. Firstly, I would like to welcome our Dr. Luqman. Welcome, Doctor. Also, I would like to welcome all our brothers and sisters to our lecture. Secondly, I would like to note that we have WhatsApp groups that contains the Nadi's news and announcement. You can press on the link in the chat and you can enter the group. Also, the PowerPoint is also in the link in the chat. Thank you, Doctor. Now we can start.
أعوذ بالله السميع العليم من الشيطان الرجيم بسم الله الرحمن الرحيم إن الحمد لله نحمده ونستعينه ونستهديه ونتوب إليه ونعوذ به من شرور أنفسنا ومن سيئات أعمالنا أما بعد السلام عليكم ورحمة الله تعالى وبركاته. Very good evening to every one of you, and especially the moderator and all the participants from different parts of the world. My name is Luqman Zakaria, a professor of Islamic jurisprudence at the Federal University of Kashiri in Gombe. Today, inshallah, for the rest of our 5 weeks, we'll be talking about Islamic legal maxims in Islamic financial transactions. The topic today will be divided into two. First, we will talk about the concept of al-Qawa'id al-Fiqhiyya, Islamic legal maxims. And we define that concept and we give a very brief historical development of the concept of al-Qawa'id al-Fiqhiyya, Islamic legal maxims. Then we will touch on the importance of al-Qawa'id al-Fiqhiyya in Islamic financial transaction in particular, and in Islamic jurisprudence in general. The second segment will be on Islamic legal maxims of intention and action, that is القواعد الفقهية أو القاعدة الفقهية الحاكمة للنية والعمل. These will be touched in different areas, meaning of the legal maxims, some subsidiaries, then application of these particular legal maxims in Islamic financial transaction. As we've known that every concept, every topic, every discipline, every subject has its origin. And by knowing the importance of these concepts, we give us the importance of the substance of the subject. Islamic legal maxims, which has been rendered into English in a legal terminology, also it is called Islamic principles or legal principles. And the Arabic version of it is Al-Qawa'id al-Fiqhiyya. It is a general rules of fiqh which can be applied in various cases that come under the common rulings. Meaning that when you have Islamic legal maxims, it will give you a general ruling that could be applied to anything that can fit into that ruling or that principle. In another version, it says that a maxim is a general rule which applies to all of its related particulars. Meaning that when we have a legal maxim, that is qa'ida fiqhiyya, we can apply many other field of furu' al-fiqhiyya, other particular issue in Islamic jurisprudence that relates to that particular legal maxims. I will give you some example later, but I'm trying to give you what is al-qa'ida al-fiqhiyya. So these legal maxims play an important role in the formation of Islamic law, for they are used as principle to deduce many rules of fiqh. Yes, Islamic legal maxims has been a very good instrumental tool for the scholars, especially the jurists, in order to formulate some principles, some thoughts. Muslim scholars, jurists, they formulated legal maxims that can govern or guide a scholar to deduce rulings, ahkam, from these legal maxims. So legal maxims are theoretical abstractions. It is nadariyat mukhtasara, usually in the form of short epithetic statements that are expressive, often in few words, of the goals and objectives of Sharia. Legal maxims, one of its features, that it is a theoretical abstraction. First, it must be a nadariya amma mukhtasara, and it must be a short epithetic statement. That is, al-kalmatu mukhtasaratin jami'a mu'athira. And it is often in a few words. Legal maxim cannot be a long sentence. It must be a very short, few words, 3, 2, 5, 6, maximums to be 10. Even 10 also may not be considered as legal maxims because it will be like a statement, general statement. But one of the features of legal maxims is that it must be concise, few words. That is why we see legal maxim like al-umur bimaqasidiha, just only few, 3 words. Al-yaqin la yazul bishak, ad-darar yuzal, and so on and so forth. All these statements are very few, but they depict or show the goal and objective of Sharia. And that is a very good remark from Kamal Hashim when he believes that legal maxims has to do with al-maqasid al-sharia, has to do with maqasid al-sharia. So from these, we will know the importance of legal maxims as it is used in fiqh to make sure that they encompass all the issues related to a particular topic in Islamic jurisprudence. When I talk about al-umur bil maqasidah, which we are going to treat today, you will see that in many aspects of Islamic jurisprudence, we use these legal maxims to depict what is the objective of Sharia in every action that we are taking in our day-to-day activities. Legal maxims are also closely related and provide perspective insights into the objective of Sharia, maqasid Sharia, to the extent that sometimes they have been subsumed under the maqasid Sharia. When you look at book of Muwafaqat li-Shatibi and host of others, they mention many legal maxims, that is qawaid al-fiqhiyya, whenever they are talking about maqasid al-sharia. And most importantly, when you look at the first legal maxims, al-umur bimaqasidiha, it depicts the maqasid al-sharia as well. And that is not even surprise, because Al-Bukhari rahimahullah ta'ala begins his book with innama al-a'mal bin-niyat, and maqasid al-sharia, or the al-umur bi-maqasidiha, is also about an-niyya. That is, anything you want to do in Islamic law, Islamic jurisprudence, in Islamic ma'amalat, ibadat, jinayat, there must be a solid intention. Without intention, the action may not be accepted or segregated or differentiated between ordinary activities and the one that you do for Allah. The word used or contained in illegal maxims are sometimes derived from the Quran or Hadith, but typically those maxims were refined and further developed by jurists over time. That is, the legal maxims is not from anywhere. It is from the Quran, Hadith, or ijtihad of fuqaha. They deduce those legal maxims from the text of Islam, Quran and Sunnah. Only sometimes they may refine the expression in order to encapsulate some of the issues that one expression may not be able to capture. So the legal maxims that we have today are developed over time. From the beginning, it may not be like that, but later it was refined and developed by other jurists. Unless they reaffirm a ruling of the Quran or Sunnah, the legal maxims do not bind the jurists in delivering a judgment. So there is no any binding enforcement of legal maxims. So you cannot use legal maxims to pronounce judgments, but we can use it to support judgments. Unless if it is from the Quran and Sunnah, directly from the Quran and Sunnah, like al-bayinat, al-yamin ala man idda'a, al-bayinatun ala man idda'a wal-yamin ala man ankara. So if this statement comes as qaida, then it can be enforceable because it represents the text of the Quran or Hadith, and at the same time, it is considered as legal maxims. Also, like la darara wa la darara, it is considered as legal maxims, but it is from Hadith of the prophets. So that Hadith is also a legal maxims accepted by the Muslim scholar, Muslim jurists, that they can use it alone to pronounce judgments in Islamic law. So they do provide an important influence in exercising ijtihad in arriving at legal decision and opinion. That is the work of legal maxims. So they use it to arrive at hukum shari'i or opinion fatwa, but not to pronounce the judgment except if that legal maxim is from the Quran or Hadith. Legal maxims are not similar to usul fiqh. We have usul fiqh as we also have qawaid usuliyya. So legal maxims is attached with fiqh, that is ijtihad, whereas usul fiqh is concerned with the source of law. Even the qawaid al-usuliyya are also attached to the source of law, that is the text, whereas al-qawaid fiqhiyya are the ijtihad of fuqaha, though deriving from the text of Islam. There are 5 leading legal maxims which will be our focus for these 5 weeks in this webinar seminar. The first one is according to intention, stated in Majallat al-Ahkam al-Adiyya number 2. That is al-umur bimaqasidiha. The second one is certainty is not overruled by doubts. Al-yaqeen la yazulu bishak. We will be treating that in the second week. The third one is hardship begets facility. Al-mashaqqatu tajlibu at-taysir. That will be in the third week. harm must be eliminated. That will be treated in the fourth week. That is ad-darar yuzal. Ad-darar yuzal. And the third one is al-mashaqqat tajlib at-taysir, if I've said it. The fifth one is custom is a basis for judgment. Al-'adatu muhakkama. Al-'adatu muhakkama. All these 5 legal maxims are considered as al-kulliyat al-kubra, al-kulliyat al-fiqhiyya al-kubra, the general great legal maxims. Other than these 5 leading maxims, there are corollary maxims, that is al-furu' al-qawa'id, which extensively cover a number of branches of fiqh, but are less extensive compared to the 5 leading maxims. So apart from these 5, we have some other legal maxims which are very important. Sometimes they are dawbits, as I will mention later on, but they are not as the 5 leading, because the 5 leading legal maxims that we are going to touch upon in these seminars are the maxims that must include all the aspects of fiqh, all the areas of fiqh, be it ibadat or ma'amalat or jinayat or ahwal shari'iyah. There is no any field of Islamic jurisprudence that those maxims could not be applied. However, the other maxims, which are not general and universal, some of them may be applied in 1 or 2 aspect or area of field of Islamic jurisprudence, that is al-fiqh al-Islami, and some of them may not be applied in those fields. So the development of this branch of fiqh is in many respects related to the general awareness of the ulama over the rather fragmented style of fiqh literature, which, like the Roman jurist writings, is issue-oriented and short of theoretical abstraction of the governing principles. What we are trying to say here is that Islamic legal maxims are developed as a result of the way the Muslim scholars are writing their books. When you look at the books of fiqh of Ahnaf, you will see that some of the scholars of Ahnaf mention many issues. Zarkhasi in his book, or Ibn Humam in his book, they mention many issues related to particular field of fiqh, but there is no anything that ties every issue they mention together. They mention about a niyyah, but niyyah, that is intention, in ibadat may not be the same as it is in jinayat. So legal maxim will not come to tie all the thought of the Muslim jurists together to make it as a statement, as a law, or as a principle or qaida that will govern a jurist, a new jurist, to navigate to all these literature so that they may not make any confusion or any error in delivering judgment. It is just like a Roman jurist writing. They also have what they call legal maxim in Roman juristic writing. In the Latin, they wrote it in Latin, and there are many books like that. So the maxims fill the gap to some extent and provide a set of general guidelines for an otherwise diverse discipline that combined an impressive variety of schools and influences into its fold. So when we have legal maxims, it tries as much as possible to guide the Muslim jurists of all what other Muslim scholars have said in different books on particular theme, like Aniya, how does it work in Ibadat? How does it work in Ma'amalat? How does it work in Jinayat? Are they similar or different? So legal maxims, qaida fiqhiyya, will give you that insight into what is going on in the book of fiqh. Is a useful bibliography of various work of Sharia. Mazim can be found in Kamal, Principle of Islamic Jurisprudence. Hashim Kamali mentioned many legal maxims, and he gave us some list of bibliography of the writings on this, which also provide an extensive treatment of the sources of Islamic legal maxims and theory. So he also made sure that is Hashim Kamali is about Islamic legal maxims in his book. Another we also did a lot of efforts to explain about the origin of legal maxims, how it was developed from one stage to another stage till our present time. His book on the Al-Qawaid al-Fiqhiyya, تأسيسها ونشراتها ومؤلفاتها is very important for any a scholar of jurisprudence today. Likewise, we have many other scholars, Mustafa Az-Zarqa and Al-Wajiz Libarno, and so forth. So, according to Kamali, there are two types of legal maxims. First, those which rehash or reiterate a particular text of the Quran or Sunnah, in which case they carry greater authority, like hardship is to be alleviated. Al-mashaqqatu tajlibu taysir. For example, is the legal maxims of fiqh, which merely paraphrases parallel Quranic dicta on the theme of removal of hardship, it is Rafu al-Haraj. There are some legal maxims which are directly quoted from the Quran and Sunnah, as I've mentioned before. And these legal maxims, we have very great authority, and it can be used as a pronouncement of law, especially when it is directly without any alteration from the Quran and Sunnah. There are some other legal maxims which are being the outcome of the ijtihad of the scholars. According to Laden, that is Tawfiq Muhammad Laden, it says legal maxim can be categorized into different classifications depending on the following two factors. First, the scope of the qaida in terms of its application towards the issue of fiqh. And the second area will be the acceptance of a legal maxims, in particular legal maxims, among the different schools of Islamic law. These are the two factors that could lead to differentiating between one legal maxims and another, according to Laden. So in terms of the scope of application towards Islamic fiqh, legal maxim can also be classified into the following. First, the major legal maxims that cover various issues of fiqh. The one I've mentioned before, it is Al-Qawaid al-Fiqhiyya al-Kulliyya, Al-Khamsa. The second one are the type of the legal maxim that cover a substantial amount of fiqh subjects. However, the coverage is lesser compared to the above category. This is the second category of Islamic legal maxims in terms of application. And we also have some other types of legal maxims which can be considered as dawabit al-fiqhiyya. So in terms of acceptancy, we have what they call legal maxims that are accepted and utilized by all scholars from different schools of Islamic law. So be it Hanafi or Maliki or Shafi'i, they will use these legal maxims like al-umur bi maqasidiha, but they may have different approaches to these legal maxims. And we have another legal maxims that can be accepted by one school and rejected by another another school of law. Like la ithar fi al-qurbat, la ithar fi al-qurbat. That is, there is no any favoritism or preference when it comes to closing to Allah or doing ibadah to Allah. So for one school, we accept it. Another school, we say that is not the principle in their school. In essence, for this class, we have divided legal maxims, qawaid fiqhiyya, into three. The first one will be major and primary legal maxims, al-qawaid al-kulliyya al-khamsa. Those 5 legal maxims recognized by all Muslim scholars, and they are very comprehensive in terms of application. The second category will be independent general legal maxim, al-qawaid al-kulliyat al-mustaqilla. They are independent because they are not part of the first category. They can stay on their own and they can be applicable to all aspects or many aspects of Islamic jurisprudence. I will explain about this in due course. The third one is particular and topical maxims. They call it ad-dawabit al-fiqhiyya. Ad-dawabit al-fiqhiyya. This category of legal maxims are maxims that control particular topic in Islamic jurisprudence. That is, it could be on ad-daman, compensation, or it could be al-aqd, contract, or it could be on al-fasakh. Any legal maxims that depicts or focus on particular topic in Islamic jurisprudence is considered to be ad-dawabit al-fiqhiyya. So in our class today, we are not going to touch on these 3 aspects of classification, but we will focus on the only first one, which is al-qawaid al-kulliyatu al-khamsa. So these are the legal maxims and their subsidiary that will be touched upon in our seminar. I believe, inshallah, we make some benefit from the class. Sources of Islamic legal maxims. It could be Quran, as it has been said in the Quran, do not devour your property among yourselves. Firstly, except that it be trading by mutual consent. Quran 4, verse 29. This particular verse of the Quran refer to the principle of taradi, mutual consent, in Islamic contracts or Islamic transactions. So, if the Muslim scholar derived legal maxims from this verse of the Quran to indicate the principle of mutual consent, that is, at-taradi fi al-uqud, it's considered that legal maxims comes from the text of the Quran. Also, it could be from the hadith of the Prophet, but it comes in in 2 ways. It could be directly lifted from the hadith without any changes, but sometimes it could be changed. For instance, la darara wa la dirara is considered to be a legal maxim on its own, whereas it is hadith of the Prophet directly. There is no any alteration, any modification in this legal maxim. However, the legal maxims can be derived from hadith of the Prophet by some alteration, like ad-darar yuzal, ad-darar yuzal. That has been taken from hadith of the Prophet, but in a modified way, or to support what the Prophet ﷺ has said in his hadith, innaka tadurru akhaka, you are inflicting harm on your brother. So the Prophet ﷺ, he didn't want any Sahaba to inflict any darar to any of the companions. In hadith of the Prophet, al-Kharaj bid-Daman is lifted directly from hadith of the Prophet, but it is considered as legal maxims. Al-Ijtihad, interpretative judgment of the Muslim scholars, that also can be considered as legal maxims, but the power, the authoritativeness of the last one cannot be like the second one and the first one. Example of the third one is man is bound to his admission. Al-mar'u ma'akhadh bi-iqrarihi. Al-mar'u ma'akhadh bi-iqrarihi. So these legal maxims, the last one is from the ijtihad of the fuqaha, but deriving from deductive experience of the scholars. Significance of Islamic legal maxims. Islamic legal maxim has many significance and is very useful in different ways. Let us see what Al-Qarrafi says regarding the legal maxims. It says, these maxims, that is, هذه القواعد, are very important in Islamic jurisprudence. مهمة في الفقه الإسلامي. By knowing these maxims, if you know the legal maxims, the value of a jurist is measured. So we can know the qima of faqih. We know the qima of al-faqih by knowing these legal maxims. Through it, the beauty of fiqh is known, is shown and known. So we know the beauty of fiqh by memorizing, have knowledge of legal maxims. With it, the method of verdicts are clearly understood. So we can know why Maliki arrives at this judgment of fatwa and why this scholar arrives to this fatwa. Whoever knows fiqh, Al-Qarafi says, whoever knows fiqh with its maxims shall be in no need of memorizing most of the subordinate parts of fiqh because of their inclusion under the general maxims. Yes, of course. If you can memorize many maxims, you may not need to memorize any furu' much. You may not need to memorize word by word of fuqaha because you will know the qa'idah that guides this scholar to arrive to the conclusion. If you know al-umur bi-maqasidiha, and you know that every madhahib indicate that niyyah is important, then when we are talking about the place of niyyah in salat, in Hanafi school, you will know that it is important for someone to have niyyah. But how he should do the niyyah could be another issue that you need to learn about. Ibn al-Najim says, it will be helpful to be cognizant of the rulings of corollaries and underlying rationale therein. This is the ground and foundation of jurisprudence, and jurists will reach at the level of practicing ijtihad and giving fatwa by applying that is, by applying the legal maxims, we will know the status of mujtahid, that this mujtahid has reached the peak of giving fatwa. So in most cases, you will see scholars in the book, when they are talking about issues of fiqh, when they finish, they will refer to legal maxims. That's al-yaqeen, because al-yaqeen la yazulu bi-shak. So this is the reason why I arrived at this particular judgment, because al-yaqeen la yazulu bi-shak. Let me give you an example. When the Malikites, the school of Maliki, arrived at conclusion that hiba, hiba is a voluntary donation, gift. So if you promise someone that you give him a gift, by nature, you are not obliged to give him if there is any reason for you not to give him. However, if you have inflicted harm to the one you promised to give a gift, and you fail to give the gift, then it is compulsory for you to do it. Even you can be dragged to the courts. Let me give you an example. You have a friend and you saw him using bad car, very old car. And you told him that, oh, my friend, this car is not good for you. Go and demolish it. Go and rubbish it. Go and throw it away. And he did. And you promised that you will buy a new car for him. But you failed to buy a new car for him. And he sued you to court that you damaged his car by giving him assurance that you buy a new one. But you failed to buy a new one. So the court can say, yes, Hiba is not compulsory, but in this case, because your word, your promise to give him a gift has encouraged him to throw away his car, which is very harmful to him, then you are being instructed to buy the car. Otherwise, you may be in debt for him, at least to buy the car that he destroyed by himself or by your promise. So this is how the Muslim scholar will give the judgment, and they will say, because ad-darar yuzal, ad-darar yuzal, because the Prophet says, la darar wa la darar. So you see how legal maxim can be used to arrive at a fatwa that is very meaningful and even having maqasid sharia in it, inherited in it. Muhammad al-Zarqa, rahimahullah ta'ala, observed that were it not for the legal maxim, the rules will have remained dispersed without any additional connection. What he's trying to say is that even because of the legal maxims, the ideas mentioned in the book of fiqh in different madha'ib may not be connected. But by legal maxims, qaida fiqhiyya, you can connect what Maliki says in his book with what Shafi'i says in his book. And you can see the difference between the two schools in terms of the approach on niyyah, or approach on darar, or approach on urf, and so on and so forth. So the idea of codification of law, as I will end the issue about the first segment of our class today, is that the idea of codification of law emanates from the codification of Islamic legal maxims. This is my observation in many writings, that when you look at the modern codification of law that has been claimed to be the legacy of the West, I believe it is fallacy to claim that the Western world has a preference over the Muslims in codification of law. Why? Is because Al-Qawaid al-Fiqhiyya has been there more than 14 centuries. The Muslim scholars started writing about legal maxims back in 14th century ago, or the 2nd century of Islam. Till today, we have been writing on legal maxims, and this qaida fiqhiyya is one of the bases for the codification of law today. If not, the Majallat al-Ahkam al-Adidiyya may not be accepted. And if you look at the Majallat al-Ahkam al-Adidiyya, you will see that many legal maxims mentioned in this book have been derived from the book of Fuqaha. Thanks to Ibn Rajab, rahimahullah ta'ala, in his Qawa'id, you see the system of his book, you say Al-Qa'idatul Ula. كذا وكذا. القاعدة الثانية كذا وكذا. القاعدة الثالثة كذا وكذا. He will mention قاعدة al-ula like the way we have it in the codification of law today, like Article 1 in the Constitution of your country. So meaning that the civilization of codification of law has been in the thought of the Muslim jurists before, but the difference between these and that is that al-qawaid al-fiqhiyya didn't go through the assent of the parliaments. That is, it doesn't pass through the reading in the parliament, and it was not passed as law, but it was written by individual jurists. Whereas the codification of law today must pass through the House of Law or House of Assembly for them to assent it or to pass it as law. That's the first segment of today's class. Now we are coming to the second segment, where we will start taking one legal maxims one by one. So today, inshallah, I will focus on the first legal maxims, which is al-umur bimaqasidiha. This legal maxims talks about intention and objective of law and what Islam or Islamic law Sharia is looking in your action and your intention. Before any verdict can be laid or can be pronounced against or support of any action, the niyyah of that action must be ascertained, must be known. So I will look into these legal maxims in this subdivision. That legal maxim will be mentioned, meaning of this legal maxim will be mentioned, some subsidiary will be mentioned, then application in Islamic financial transaction will be explained. Al-umur bimaqasidiha, al-umur jamu amr, and al-umur could be an action, be it verbal or physical, be it verbal or physical. So al-umur here is used to include verbal and physical action, your expression and the one that you did physically. Because sometimes we may not know intention from the verbal, but from the action. Let me give you an example. When someone kills another person, as a result of his action, someone dies. When he dies, he may claim that it is by mistake, but we can know his intention, the intention of the action, from the way he does it. If he slaughtered the person, we say that he did it intentionally and he has to be punished. Unlike someone who just throws a stone and hits someone and the person dies, then we can say that that action he did is not intentional, because throwing a stone somewhere does not mean that he wants to kill another person, but it could be by mistake. Maqasid is intention behind exercising the action. So the inner intention or the obvious intention, as I mentioned, in slaughtering someone, the intention can be deduced from that particular action, not necessarily the inner intention. So the inner intention can be used in ibadat, but in mu'amalat and jinayat, the visible intention will be emphasized, Let me clear this for you. When someone prays, he does prayer in the mosque. We cannot say that he doesn't pray, but to Allah, he may not, because we do not know the intention, whether he's praying because of the imposition by the employer? We do not know. So we say he prays. Okay? But Allah knows that it doesn't pray for him. He may not accept the prayer, but that is not in our jurisdiction. As opposed to someone who says to someone that I gave you this money as a gift, or I gave you this good as a gift, but I would like you to give me 100 dinar. It says something, but the intention may be to gift, but what he's doing contradicts to the intention. So in these, the Muslim scholar will now look into the action and what it is the intention of that action, or what that action indicates, implies, when we want to put it in a very concise manner. Thus, every deed shall be considered according to the intention of the doer, be it in ma'amalat or in jinayat or ahwal shakhsiyah and so on and so forth. Factor rendering actions not concurrent with intention. Sometimes our action may not be in consonance with the intention. You do something, but it doesn't correlate with the intention. You throw a stone out from your house, but it hits someone and the person dies or injured. That action may not corroborate with your intention. Or your action is to sell a house, but unfortunately, that house, there are inside it some things that it is not meant for selling. So your intention is not to sell the money or the luxury in the house, but you sold the house, but you do not have the intention of selling some other things in the house. So action sometimes may not corroborate with the intention. So there are 4 factors. First one is ignorance. If you are ignorant of the thing or of the law, then your intention, your action may not be in consonant or not concurrent with the intention. أضرب لكم مثل. If you engage in a transaction, that it is not allowed, but you do not have intention of doing it, you may be exonerated from Allah's sight, but in the Monday, that is in lively one, you may not. Let me give you an example of this ignorance. You are packing your commodity to sell, but unknowingly, there is something that is harmful in it, maybe flies or poison or something like that, and you sell it, and it causes damage to others. You may not be sinful to Allah in Allah's face, but you may pay compensation, and you may not be punished as killing a human being if that commodity leads to death. Coercion, ikrah, can also be factor. When you are being compelled to sell something, you are being compelled to sell something, whether because of your boss or because of any external factor. So you sold it. It can be retrieved back to you. It can be taken back to you because you are being compelled to sell it, not from your own choice. Error also khata. You sold it by mistake. For instance, you have 2 houses, and one you kept some money in it, and something you are not meant or are not meant to be sold. And the other one, So you sell your house, but you didn't know the one that has that luxury belongs to you. But you are not intended to sell it. But unfortunately, by mistake, the one that you didn't want to sell is taken by the buyer. That is hotter. Then you can retrieve it back and give him the one that you wanted to sell. Even when you go to the court may judge that it is not meant to be sold, so you should return the commodity back to the owner and you will get the one you should buy. The fourth one is puberty al-bulugh. If someone who is not attained the age of puberty, that is ghairu baligh, sold a commodity, he won't be punished, and even that contract may not be effected simply because he doesn't have the niyyah sahiha, that is good intention to sell in a good terms. So the Muslim scholar will revert anything sold by a child who doesn't attain the age of puberty. So intention, also moral and immoral action. Intention also comes into moral and immoral action. So intention are central to the ontological approach as they determine whether or not business decisions are ethical or unethical. Only when members of the business community act from duty to their action have moral worth. An action is not considered worthy of moral rights if it is taken out of self-interest as compared to one which is taken from a deep sense of duty. This statement indicates that sometimes if you do something in an immoral way, but you do not have intention of doing it, you may be exonerated. But if you have intention of doing it, you may be punished or your action may not be accepted by the Prophet. Let me give you an example. When the Prophet ﷺ went to the market and he saw some item, some vegetable that are very nice on top, and he put his hand in it. He put his hand in it, and he saw some bad item beneath. And he asked, what happened to this? He says, there was rain that befell it, and that's why the inner one is spoiled. And the Prophet told him, why can't you put the spoiled one on top and the good one beneath? Man ghashana falaysa minna. If you have intention of deceiving people, you are not part of the community of Islam. So that indicates that sometimes if you have good intention, but your action does not depict that good intention, you may be incur punishment and your deed may not be accepted by Allah subhanahu wa ta'ala. Subsidiary maxim of the main maxim, that is القواعد الفرعية تحت قاعدة الكبرى الأمور بمقاصدها. We have one very important legal maxims here, which I think it is very important to mention before we finish today's class, is that in contract, attention is given to intention and meaning, and not words and form. العبرة في العقود للمقاصد والمعاني لا للألفاظ والمباني. في العقود العبرة للمقاصد والمعاني لا للألفاظ والمباني. This particular legal maxim is very important in contracts, in Islamic contracts. So the general meaning of the maxim is that the maxim clearly states that it is the underlying object and aim of a transaction which will determine the legal position of that transaction. In the event of a difference between the wording of an expression and its meaning, consideration should be prior to the meaning and not to the literal wording, such that in determining the validity of a transaction, we should consider the economic substance over legal form. This legal maxims is very important to differentiate between a conflicting wording and the meaning. Let me give you an example. If you use the word al-fa'ida, that is profit, you use al-fa'ida in the contracts, that after this contract, I will give you fa'ida of this. And you call it Islamic contracts. But when we look at the way you do the form, the way you do it is like a riba. Then the wording you use will not be considered, but the meaning will be considered. Let me give you an example. The Prophet ﷺ was given good date by Bilal. One of the Sahaba, he brought a date to the Prophet. And he told the Prophet that this date was exchanged with bad date. And he got the good date in order to give the Prophet. And the Prophet says, how we ainu riba. That is, the way you do it doesn't mean that it is not usury. The way you do it is ainu riba, is exactly the form of riba. So leave it, don't do it. Why can't you go and sell your bad dates and buy the new good date with the money you derive from it? So meaning that sometimes when you do something, the form you use may not be accepted. So we look into the meaning of that action or what that action replicates. Another example of this is that when I told my friend or someone that I want to rent you these, I want to give you hiba of this good, like my laptop, but you have to give me particular amount of money, a certain amount of money. This is not hiba. Though you use the word hiba, that is gift, but it is not. Simply because if it is hiba, there will be no any exchange. You do not need to get something back from him or her. It must be without any value exchange. So the implication is that if he gives you $100 for that particular gift, if that gift is not good, is not working, he should return it back to you. He has the right of returning khiyar. Okay? And also, he may retrieve his money back because you do not give him what commensurate with the money you requested from him. As opposed to a gift, if the gift is not good, you do not need to return it back. That is the consequence of the difference between the wording and the intention. So we consider that contract as bear. We not consider it as hiba, simply because the wording does not commensurate or the wording contradicts the intention and the meaning of the transaction. Okay? Importance of this legal maxim. Based on interior motive, the Prophet prohibits any loan that brings benefits. كل قرض جر نفعا فهو ربا. كل قرض جر نفعا فهو ربا. According to the scholar, it says al-qard, it is supposed to be free. There shouldn't be any benefit derived from it. But if you have given condition for that qard, that you want to benefit from him or her, there is no longer qard. Is no longer qard. So if there is any shart, and yabi'u shay'an, you have to sell me another good. أو يأجره داره أو يقرضه مرة أخرى. قال الخطابي ولا خلاف في المنع من أن يسلف الإنسان شخصا ليسلفه بعد ذلك. Because the intention behind it is not accepted from Sharia point of view. And this issue has been used in Imam Shafi'i approach to Bay'ul Ina. When he was saying in Al he says, if someone comes to him and he asks him that, is it good for me to sell something for another person, mu'ajjala, and buy it mu'ajjala, ajilan. If he doesn't explain that he wants to do it as ina, there will be no problem. But if he declares that in order for him to get money, then I will say it is ina and it is riba, so don't do it. So sometimes the motive behind any exercise, if it is not clear, we may not be able to differentiate between that action, whether it is good or bad, or the one that is done in a good faith. But if it is pronounced, then we can now say this is the fatwa or this is the ruling against that action. So the importance of al-qa'ida fil niyyat wal maqasid is very important. So all Muslim scholars who are dealing with Islamic finance should know all the ways of application of these legal maxims, because sometimes if someone doesn't explain or declare its motive, you may not be able to ascertain whether the action is good or not. But if it is declared, then you can give judgment on it. Application of these legal maxims, in a few words, I will not go into detail. I will explain in a very brief because of the time. So intention in possession of ownership of a property. This is a classical example. If I see something on the street, on the road, and I take it, but my intention is to use it for my own purpose, then if there is any fault in it, if there is any problem on this commodity, I must pay it back to the owner, as opposed to the intention of keeping it for the owner. If I take it on the street and I consider it as luqta, that is something that is lost, and I found it and I keep it for someone, but it is destroyed, I'm not supposed to pay back that commodity because I'm amin. وَيَدُ الْأَمِينَ لَا يَدْمَنْ Yadul Amin la tadman. So Al Amin, someone who is trustworthy, cannot pay back something that is being destroyed under his custody. The same thing is Al Wadi'a. If it is used by a shorty and becomes lost, the shorty must pay compensation. So when you go to the bank now, today when you go to the bank and you put your money in a saving account, and the bank uses this money to do business, if there is any problem with your money, it must pay you back the money. As opposed to the wadi'a originally. If wadi'a is destroyed or lost in the hand of al-muda', if the money is lost or the property is lost, then he is not supposed to pay back compensation to the owner of the property. The Maxims is used also to nullify any way of ruse or trick in Islamic law. Based on these, some scholars rejected Bay'ut Tawarruq, especially if it is organized one, because it resembles al-ina. There are discussion on Bay'u Tawarruq. Bay'u Tawarruq, as I mentioned in our last episode of seminars, is when you buy something from someone mu'ajjalan, okay, and you sell it in another market ajilan. You get your cash in another market. It's very close to al-ina, especially if it is organized one, meaning that when one office in the bank, Islamic bank, sells something for you for 10,000, and the second office, immediate office, buys the commodity from you less than that money, and it pays you cash. That is organized because it's within the company, but different offices. Different offices. It's an organized tawarruq. So the Muslim scholar said that the intention is to use what they call ruse or trick to get money, and it is like bail al-ina, and which is not accepted in Islamic law. The same thing, the Muslim scholar condemned hiring a weapon to a criminal who will use it to kill innocent Muslims because of the intention. If not, if there is no any bad intention, it may be accepted. Yes, I've mentioned about the hiba as well. The hiba with the condition of counter value will not be accepted because it is not hiba, it is sales. Okay. Based on the consideration of action in intention, the principle of some banks that resembles ina is prohibited by Al-Baraka in his one of the Sharia committee of Al-Baraka. They do not approve purchasing of a commodity by a company on credit for $20 and then sell it for $15 to a sister company, thinking that they are trying to deceive or to trick Islamic law. That is why they come to that conclusion, because of the motive behind the action. Also, the Fiqh al-Islami in its 12th section in 2000 resolved that it is not permissible to issue a credit card or use it if it is condition, its condition include imposition of interest. If there's a condition that there will be interest, if you do not pay after 1 month, this is so even if the card holder has the intention to pay the price within the moratorium period that precedes imposition of interest. You know, you will be given credit card and they will say, if you use it this month, they will give you your bill next month. If you can pay this money within short period, say 1 week, 2 weeks, 3 weeks, you are not going to pay interest. But if you do not pay after so dates, you are going to pay interest. The Muslim scholar arrived to conclusion that it is not permissible for you to use that credit card because of initio, at the beginning, they have imposed on you interest, and that is not accepted from Islamic point of view. Similarly, price drop is not accepted, especially if they are taking money from 3, 4, 5 people with the intention that one will lose and one will gain. One will lose, one will gain. And they will also benefit from selling these tickets to many people. So when they sell tickets for many people, and after the gambling, the draw, only 1 or 2 people got it right, then the price they are giving is like gambling, and the other party who lose is like doing something which is not accepted, like jahala and gharar. For that reason, the Muslim scholar says it is not accepted to participate in such prize drawing. So this is the end of today's class. I believe that you benefit at least one or two issues in this presentation. We ask Allah subhanahu wa ta'ala to reward the listener and forgive us any of our shortcomings in this class. وصلى الله وسلم على عبده ورسوله سيدنا محمد وعلى آله وأصحابه وسلم تسليما كثيرا. Thank you very much for listening. I think I go beyond.
Thank you, Doctor. Very nice lecture. Now we can go to the questions. If anybody has any questions, you can either type it in the question answer bar, or you can, if you want to ask the doctor directly, you can raise your hand and I will allow you to ask him. If you want to ask the doctor directly, you can raise your hand.
And if it is in Arabic, also it is accepted. If you want to express in Arabic,
also in Arabic,
I can take it.
Ustad Hana, you can ask Dr. Luqman. You can open your mic and ask the doctor. Ustad Hana. I think Sabi, you can talk. You can ask the doctor. Sabi Hamza, you can open your mic and ask the doctor. Ammar Farouk. Ammar Farouk. You can open your mic and ask the doctor.
السلام عليكم ورحمة الله وبركاته.
وعليكم السلام ورحمة الله تعالى وبركاته.
حيا الله شيخنا، جزاكم الله خيرا. نعم، أريد أن أسألكم ما الفرق بين البيع والمناقصات؟ هل يوجد في بيع المناقصات محرم أيضا؟ لأنهم إذا اشترطوا مثلا الشركة أخذ الأمولة قبل المشاركة فيها. في البيع
إذا اشترطوا
إذا اشترطوا أخذ الأمولة من المشاركين قبل المشاركة فيها، وأعلم بأنهم مثلا سيفوز واحد فقط منهم، بل لكنهم اشترطوا أخذ الأمولة أو دفع الأمولة للشركة قبل المشاركة فيها، مثلا يكون الأمولة لتوصيلهم الرسالة وما أشبه ذلك.
نعم، هذا الذي قلنا أخيرا أنه يشبه القمار، لأنهم دفعوا فلوس. دفعوا فلوس، فإذا لم يدفعوا فلوس فلا شيء في ذلك ما دام أن ليس هناك مقابل.
نعم،
فدفع فلوسهم يشبه أنهم يشترون شيئا، فإذا دفعوا فلوس ولم يحصل على شيء فلا فائدة في ذلك، فكأنهم لعبوا القمار، فالقمار يعني محرم شرعا، فلذلك يدخل في باب المحرمات في العقود. طبعا النية ربما نية المشاركين ربما لم يكن الأصول أو اللعب في القمار، ولكن هذا اللعب أو أسلوب اللعب يدل دلالة على أنهم يفعلون شيئا محرم، والله تعالى أعلم.
نعم، جزاكم الله خيرا. عندي سؤال آخر. مثلا في الشرط الجزائي، مثلا إذا يعني أجل، السلام عليكم، في الشرط الجزائي إذا أجل المدين يعني دفع المدين عليه، واشترط في العقد أنهم إذا أجلها سيدفع أمولة شرط جزائي، هل هذا أيضا محرم؟
إذا فعل ذلك في بداية العقد فهذا محرم، أما إذا دفع متأخرا وزاد عليه فلا شيء. إذا لم يكن من الشروط
نعم.
إذا لم يكن شروط العقد جاز، هذا من باب الرد بالإحسان. أما إذا اشترطوا على ذلك في بداية العقد فيشبه الربا، والله تعالى أعلم.
نعم، جزاكم الله خيرا، أحسن الله إليكم.
نعم.
Muhammad, Ustad Muhammad, you can open your mic and ask the doctor.
Assalamu alaikum. Do you hear me?
Yes, we can hear you.
Thank you for kindness, Sir Sheikhana Al-Jalil. Please, I would like to ask you for loans called the DART here in Morocco. DART is in Arabic. A group agree on amount, each one pays his parts every month, and one of them benefits once, by lot or consent. Shall I translate in Arabic, yak, sir, no?
اسألني بالعربية وأترجمها بالإنجليزية.
طيب أستاذي، شكرا. أولا السلام عليكم وشكرا شيخنا الجليل، بارك الله فيكم. عندنا هنا في المغرب نوع من السلف يسمى دارت، يعني كأنها تدور، يعني عدد من الناس يجتمعون على مبلغ من المال، كل واحد يؤدي قسطه في الشهر، ويتم كل شخص يعني يستفيد مرة في الشهر، مرة واحدة يعني في السنة، عن طريق القرعة أو عن طريق التراضي. نريد يعني هل هذا جائز؟ بارك الله فيكم وجزاكم الله خيرا.
نعم، هذا من باب التعاون على البر والتقوى، والقرع يعني جائز في هذا المجال لأنهم يتعاونون. فمثلا واحد مجموعة 10 يدفعون 2000 في كل شهر لشراء البيت الواحد. فواحد يأخذ في هذا الشهر لشراء البيت، والشهر القادم واحد يأخذ جميع 10 لشراء البيت إلى آخر المطاف. فهذا جائز لأن ما في شيء يعني يدل دلالة أن فيه القمار أو عقود محرمة، إلا أنه يسمى بالتعاون على البر، مساعدة الآخرين. فهذا ليس في المغرب فقط، وإنما في جميع أنحاء العالم، حتى في الغرب والشرق وفي أفريقيا يفعلون ذلك، وليس هناك خرج، اللهم إلا إذا كان هناك زيادة ونقصان فيما يأخذ واحد بسبب تأخره أو تقدمه، فربما يكون هناك.
طيب أستاذ، أنا أعتذر يعني فقط تعليق بسيط. هناك بعض الله يهديهم بعض المتشددين يقولون أن هذا يجر منفعة، يعني لذلك فهم يحرمونه، يقولون هذا القرض يجر منفعة يعني. نعم،
أنا لا أرى في ذلك عيب ولا شيء محرمة، ما دام أن نفس المبلغ هو الذي يأخذه كل واحد.
نعم، بارك الله فيكم
ولا زيادة، والله تعالى.
بارك الله فيكم، شكرا للجميع وشكرا للمنظمين، بارك الله فيكم.
For the benefit of those who understand Arabic among us, the person is asking, when we have contribution every month among group of people, and when we take it by draw this month, the next month until they finish that front? Is it allowed from Sharia point of view or not? The Muslim scholar, as far as I know, there's no anything wrong in it, in as much as all of them agree on that way of doing it, and there's no any increase or decrease in the amount of money one is going to take. So all of them take the same money, but in different months, but they are helping each other. And it is considered under cooperative. It's considered under cooperative, which is allowed at-ta'awun ala al-birri wa taqwa. So to help others to buy a house, to buy a car, to do some of the things that they want to do. There is nothing wrong in it. Wallahu ta'ala a'lam.
بارك الله فيكم. أستاذ ولا أو أستاذة ولا أو ولا. أمامة محمد. You can Umamal Muhammad. You can open your mic and ask your doctor. Umamal Muhammad. Muhammad Murshid. Muhammad Murshid. You
Yes.
can open.
Okay.
I can hear you.
Okay, just right. Please, 1 minute. I thank you for the good management for records and the content. I would like to know all the rules of fundamentals stable for explaining economic series. Retain
No.
I would like to know all the rules of fundamental
إذا أنت تسأل بالعربية فممكن.
Okay.
يمكن بالعربية كمان.
Okay.
فهمت معرفة القواعد ولكن ما فهمت ما هي الألفاظ بعد ذلك.
هو السؤال هل يصلح القواعد الأصولية إن إحنا كل القواعد الأصولية الكلية اللي موجودة في الفقه تصلح لتفسير كل النظريات الاقتصادية أم أن هناك بعض القواعد يصلح وبعضها لا يصلح؟
نعم، في بعض القواعد الأصولية كما في بعض القواعد الفقهية، وهناك فرق بينهما كما فصل الفقهاء في كتب الفقه أن هناك فرق بين القواعد الفقهية والقواعد الأصولية، أما هناك بينهما عموم وخصوص. وبعض القواعد الأصولية تصلح توظيفها على المعاملات أو العقود المالية المعاصرة، وبعضها لا تطبق، وخاصة إذا كانت ضابطا فإذا كان ضابطا صالحا في عبادات أو في المياه فلا يصلح في تطبيقها في الاقتصاد الإسلامي. ولكن هناك جم كثير من القواعد والضوابط الفقهية الحاكمة للاقتصاد الإسلامية، فأحيلكم إلى موسوعة الشيخ علي أحمد الندوي، حيث عنده ما يسمى بموسوعة القواعد والضوابط الحاكمة للمالية. فهذا الكتاب يعني مهم جدا لأمثالنا. وهناك كتاب لدكتور الحسين القواعد والضوابط الفقهية للمعاملات المالية عند ابن تيمية. هذان كتابان جيدة جدا ممتاز في جميع القواعد الفقهية والأصولية الحاكمة للاقتصاد الإسلامي. فإذا رجعت هذين الكتابين ترى فيهما ما يغنيك عن العلم، والله تعالى عالم. نعم.
آخر سائل. I don't know how to pronounce the name. Willa Isah. You can open your mic and ask the doctor. It's spelled W-I-L-L-A-H. Okay. Thank you, doctor. There are no more questions.
Okay, thank you very much for having me today. Thank you, Dr. Muhyiddin, I believe. Is it Dr. Muhyiddin?
Me? No, I'm Abdulaziz. I'm not a doctor.
Okay, so Abdulaziz. So thank you for moderating the class. And
Thank you.
you to all the clubs, our club all over the world. We ask Allah subhanahu wa ta'ala to give us the reward of listening to this lecture and to make it beneficial for us in this life and the hereafter. Wassalamu alaikum wa rahmatullahi ta'ala wa barakatuh.